Today, much of our law is contained in Acts of Parliament and in things called statutory instruments, which are made by Parliament, but they are of a lesser formality, but every bit as binding as an Act of Parliament. We also have law from Europe in the form of regulations, some of which are directly binding. So that's one body of law. There's also the common law, which isn't in an Act of Parliament, but it contains some fundamental and basic rules. So all of that, you would say, is the law. Justice is a concept rather than a set of rules. Justice is an objective or a target. Sometimes the law does not produce a just result. For example, if it's a law which is out of keeping with modern conditions, you might get a result which was thought to be just in 1820, but is not just in 2012. A great deal of law allows you to produce a just result. A great deal of law doesn't lay down a rule that's cut and dried. You don't use a measuring stick to say, well, the answer here is this or that. What the law says is that the court may do one of the following, and you then have to look at the circumstances of the case, think which result is the fair one, if you like, the just one. Magistrates deal with criminal cases. They deal with the less serious criminal cases. They don't deal with crimes like murder or rape or armed robbery. They may process those cases, for example, give or refuse bail, and make preliminary decisions as to how the case should be managed, but they don't try and determine those cases. They determine the less serious cases. Most of what the magistrates do is they decide on fact. They decide who to believe. Did it happen? There is, of course, a criminal jurisdiction which is administered in the Crown Court. There are two types of judge who sit in the Crown Court. One set are circuit judges, and the other set are High Court judges. But they are High Court judges from the Queen's Bench Division. The principal work of the High Court is civil litigation, resolving disputes of a civil, that is to say, not criminal character. You've got the Chancery Division, the Queen's Bench Division, and the Family Division. The Chancery Division has some specialist jurisdictions that the other divisions do not do. For example, there's an area of the law we call trusts, where property is held in somebody's name for the benefit of someone else. That is typically in the Chancery Division. In the Queen's Bench Division, the judges also have a civil jurisdiction. What they do, which the Chancery Division doesn't, is they do what's called public law. So they do judicial review, challenges to action by the government or a local authority or other public bodies. The Family Division deals with divorce, children, and many of the disputes that are related to that. The Court of Appeal is itself split into two divisions, the Civil Division and the Criminal Division. The Court of Appeal does a huge range of work. They have appeals of all types. Some involve procedure, some involve allegations that the procedure was not fair and the decision shouldn't stand. Others involve very tricky points of law, some novel, some which have never been decided before and have to be decided for the first time.
The Supreme Court hears cases that have the most significant points of law of general public importance attached to them. The test that the justices apply when deciding whether or not cases will be heard here is whether or not the appeal raises a point of law of general public importance. So the justices in most of the cases will review the papers that are submitted by the parties to see whether or not they feel that that appeal hits that test, whether it meets that test, and whether or not a point of public or constitutional importance is raised by the appeal. The added dimension that the European Court of Human Rights, which sits in Strasbourg, brings, comes by virtue of the fact that Parliament, through the Human Rights Act, has signed up to the European Convention on Human Rights. And therefore, this court does have to pay considerable attention to the decisions of the Strasbourg Court when reaching its own decisions. And individuals, if they raise a human rights point in their appeals in the courts in the United Kingdom, do have the right to apply to Strasbourg for permission to appeal their decision in the court in this country, if they feel that their case has been wrongly decided.
We have an important principle in this country of open justice. So, with some limited exceptions, the courts are open to the public to walk in between 10 o'clock in the morning and I think about 4:30 in the evening, walk in, open the door of any court, sit at the back. No one will cause any difficulty, challenge you, ask you what you're doing. You'll be free to sit there. You can take notes. You can come and go. It's not an ordeal to go to court. Everybody should try it and see what they make of it.